Hello, good afternoon. I'm going to be talking about the Intimate Adult Relationships Bill. And this is my answer to the question, if you could change one thing in family law, what would it be? And I'm going to be arguing in this presentation that if I could change anything, it would be to bring about an act which is called the Intimate Adult Relationships Act. And that act would consolidate and modernise the law on intimate adult relationships in the way in which I'm going to explain in this presentation. Now, according to its website, the Law Commission's role is to ensure that the law is fair, modern, simple and cost-effective. And what I'm going to be trying to explain in this presentation is that the law on intimate adult relationships currently fails all four of these tests. It's not fair, it's not modern, it's not simple, and it's not cost effective. And indeed, the fact that the law is so complex is itself something which I fear leads to injustice. The number of confusions and myths that surround the law as it currently is. And that's because the law has failed to keep up with changing social realities. The law on intimate adult relationships is mostly found in the Marriage Act 1949, although there's a number of other pieces of legislation, and that itself leads to confusion. But the Marriage Act 1949, as you can see, is a statute that dates back to the 1940s at least, because most of its provisions are older than that and reflect historical quirk rather than sociological reality. And this is shown in the way that there are now a number of intimate adult relationships that exist outside the Marriage Act 1949. Cohabiting couples, for instance. What are we calling unregistered religious marriages? And non-religious belief marriages. So unregistered religious marriages are religious ceremonies that do not comply with the Marriage Act 1949. Non-religious belief marriages is a label I'm using to describe any form of marriage conducted by a belief organisation or any other non-religious organisation. And that's because the Marriage Act 1949 distinguishes between marriages solemnised according to the rites of the Church of England, with the context of marriage law also includes the Church in Wales, and all other marriages otherwise solemnised. The big division in marriage law is between marriages according to the established Church of England and all other marriages. Now, just that fact will automatically underline that we're dealing with a somewhat archaic law here. And this second category of marriage, so marriages other than those solemnised by the Church of England, includes four groups. Civil marriage in a register office or approved premises. Marriages according to the usages of Society of Friends, Quaker marriage. Marriages between a man and a woman professing the Jewish religion according to the usage of Jews, of Jewish marriage. And finally, marriages in any place of worship registered under the Places of Worship Registration Act 1855. So those are the four categories of marriage in addition to Church of England marriage, which is recognised under marriage law. And this means if we return to our three excluded forms of intimate relationship, we'll see that cohabiting couples are excluded completely. They're not covered under the Marriage Act, and indeed, unlike other jurisdictions, English law does not have a scheme providing cohabitation rights on separation. For non-religious marriages, they are not protected under the Marriage Act. They fall in a gap in the law, because the fourth category, as we've just seen, is marriages in a place of religious worship. So marriages conducted by a belief organisation are not covered under the current law. And unregistered religious marriages, now there's no gap in the law here, but the law indirectly discriminates because it only permits Church of England, Jewish, Quaker, or any other religion, provided that other religion has a place of worship. So it indirectly discriminates against those faith groups who either have no place of worship or have a tradition of marriages taking place elsewhere. The same points 2 and 3, they have the same effect. A non-religious marriage, so conducted by Humanist UK, for instance, or an unregistered religious marriage, so a religious ceremony that takes place outside a place of worship, the effect is the same. Those ceremonies are not legally binding. And so if the couples want a legally recognised marriage, then they need a civil ceremony in addition to the wedding. Now you might say, fair enough, but that adds extra cost, which is one of the issues the Law Commission looks at, and also there's a risk that the couple might decide to might never get around to the civil ceremony, or indeed one party might decide that although they want to have that wedding, they do not want the full responsibilities that come with being married legally. Now this matters because unless and until the couple also undergo a civil ceremony, they are not entitled to legal support on relationship breakdown. So a couple who have a non-religious marriage or an unregistered religious marriage, unless they also have a civil marriage, unless they also go to a registrar, then if that relationship breaks down, they are not entitled to legal support. And this is a risk if the decision not to get a legally binding marriage is not an autonomous and free choice, either because one of the party puts on pressure or because of ignorance of the legal position. And there's all sorts of reasons why, looking solely at unregistered religious marriages for a second, why people might not register their marriages. It might be because the law is unduly complex or restrictive. And if that's the case, then it does require legal reform. It might be as part of a choice on one or both of the parties. And indeed, in some religious traditions, a religious marriage is a way to date, to be together in an unchaperoned way. So they don't want a legal marriage at that point. It might result from an awareness of the legal position, or it might not be a voluntary decision by one of the parties. So there's a whole sort of reasons, and other work has shown why there's all sorts of reasons why people enter into cohabiting relationships and do not marry. And there's also going to be reasons why people might enter into a belief marriage and not have a civil ceremony. So it's not a straightforward issue of there only being one reason for these things. And you could argue, why look at this again? Why am I arguing this needs to be looked at again by the Law Commission? Indeed, they're currently looking at the law on getting married. They published a consultation paper last year. They're currently working on a final report, which is due out imminently. And indeed, they've already looked at the law on cohabitation. So why look at this again? Well, the Law Commission's work on getting married, the work on weddings law, which, as I say, they published a consultation paper last September. They're currently working on the final report. If they do what they said in the consultation paper, and there's an if there because I don't know, then their proposals would mitigate the issue of unregistered marriages, because their basic proposal would be to move from a focus on buildings, on registering buildings, to recognising of what they term officiants. So that would mitigate some of the issues of unregistered religious marriages, because those unregistered religious marriages that take place because of the harshness of the law would now take place in a way which would be legally binding. Their proposals could, with some revision, I suggest, solve the issue of non-religious belief marriages, because their scheme would allow belief marriages to take place, because it would allow belief officiants to be registered. I say with some revision, because I've got some concerns about where the Law Commission draw the line. And you can read about that in my work on this, which I will mention later. And indeed, the Law Commission's report would do nothing for those who cohabit without any form of a relationship. It's not a solution in relation to cohabitation. And in my work, and this is a book which is now available from Bristol University Press, and do order it from their website because it is cheaper from their website than elsewhere. But in my book, I argue, as I've been saying, that the Law Commission's proposals would mitigate the problem of unregistered marriages by removing those requirements, required building, but indirectly discriminate against some religious groups. They would also reduce the number of, and that would reduce the number of unregistered marriages, but only those which occur because of the strictness of the law, or because people are not aware of the requirement. So it wouldn't mean that there would be no unregistered marriages. Indeed, I don't think that would be our aim, because as I've said earlier, there are some really sound reasons why some couples would want an unregistered marriage. And I think we have to be careful here not to be overly paternalistic, whilst at the same time ensuring that people have access to rights. So it's a very difficult tightrope to walk. So some unregistered marriages would still exist, and in some cases it would not be an autonomous and free choice. And that's where I think the law needs to get involved. That's, I argue in the book, is the line here. But we should be protecting people if it's not an autonomous and free choice, not to enter into a legally binding ceremony. And as I've been saying, the Law Commission's report does not solve the cohabitation issue, as they themselves concede in their report. So my proposal is there's a need to implement the reforms previously worked on, but within a wider framework, because simply continuing this pattern of ad hoc reform continues to lead to confusion. And so what I suggest is that the Law Commission now needs to look at a consolidation project on intimate adult relationships generally. And that would allow the Law Commission to return to its previous work, including the work it's currently doing on getting married, but also looking at cohabitation law, and indeed looking at other aspects which it hasn't looked at. The interaction between civil partnerships and marriage, for instance, the differences between same-sex and opposite-sex marriage and civil partnerships, for instance. All these things, I argue, are factors that lead to confusion, and that confusion is leading to inequality and the denial of rights. And indeed, this would allow the Law Commission to update its previous work in light of the change in legal, political and social situation, which includes a review of the current Scottish law on cohabitation by the Scottish Law Commission. And indeed, the Scottish example is something which now needs to be looked at in some detail to see if we can emulate that south of the border, but learn the lessons from that. And as I've been saying, a consolidation project would provide the much needed opportunity to modernise, update and simplify the law. So my proposal is the Law Commission should explore the possibility of what I call in the book an intimate adult relationship bill. And this would consolidate the law on opposite sex same-sex marriage, opposite sex and same-sex civil partnerships, and would introduce a limited opt-out system of cohabitation rights on separation. And what the Law Commission should be looking at, in my view, is whether or not this is something which is achievable, what are the pitfalls, what are the advantages. And this is something which I argue for in my book, Religion and Marriage Law, The Need for Reform. And that book looks at more detail at the problems. It looks at what the Law Commission is proposing and then puts forward a solution, which would be the limbs, really, of the bill I've been talking about today. A bill which modernises marriage law, but also includes cohabitation rights. Thank you very much for listening. My contact details are on there. If you have any queries, please do not hesitate to contact me. Thank you very much indeed.